Yeah.
Hello and welcome to Legalese. Yeah, I'll be okay. This is Small Claims Court Part 2, and we're going to be talking more about the enforcement and appeals part of the process as we go on here. A couple of things that we just wanted to reiterate from Part 1, which was a show that we had done prior to this on filing of the claims and the procedures and so on, is that when you get prepared for trial, it's very informal, but when you come to court, bring what you need, because it's not, I want to be a millionaire, and you don't get to call a friend, and you don't get to ask the clerk magistrate to call a friend for you. You need to have your evidence with you. And a lot of people think that they can just say, oh, well, I'll get that for you later. Well, you can't, because it is a trial that you're going through now, and you need to understand that this is your one and only chance. So be prepared, bring it with you. Wendy, you want to say anything about it?
Oh, absolutely.
Thought you might.
I would say be organized. Make an outline if that is helpful to you. Have your documents. I mean, I think a lot of folks are not comfortable in that setting in front of people, and nerves may take over, and you may forget something. And if you have an outline, you have cues to follow. And it will also prevent you from being derailed into conversations that might not be relevant. So be organized. There are several places you can get prepared. You can always come to court and watch a session prior to.
Right.
The trial court has informational pamphlets. A lot of the law schools have informational pamphlets, and all are designed to help. And the law libraries. Yeah. So, but be prepared. You're telling a story, but you also are trying to make a legal case. And if you forget something really important, as we said, there aren't do-overs. You don't get to say, gee, can I bring this back because I went out and checked on this and now I don't think he was telling the truth. It doesn't work that way. This is your one. And so be organized, be prepared.
Mm-hmm. The other important item that we didn't really touch a whole lot on was an agreement for judgment, which I think is an important tool for both sides, plaintiff and defendant. And what it does is it gives you an opportunity to sit down and come to some agreement, as we discussed a little bit. But put it down in writing. And when you do that and sign it, make sure it's what you want to do. Make sure you're going to perform on that. This is not just to get out of court today. You need to actually believe that you're going to live by this, because later on it's going to be enforced.
There are consequences.
Right?
And we had talked earlier about the most recent rule changes. One of the rule changes was to improve on what we as clerks do in terms of agreements, certainly, that we're going to ask you questions, or at least the rule would suggest we do that. And I want to know, if it's me, I want to know that, first of all, you know what you're signing and why you're signing. You're not just doing it to get out the door. And if you've agreed to make payments, for instance, at a certain rate, that you have the ability to make those payments. One of the pieces of the puzzle that always amuses me is I will often ask, do you know where you're to make the payment to? And they'll say, haven't got a clue. And that's an important piece of the puzzle if you walk out without that information. And so, agreements are a large part of our business. I think they're a good thing. We might or might not touch on the exemptions, that there are certain exemptions which say you don't have to pay. But it's important that you go into an agreement in an informed way, because there could be consequences. Right,
later on down the road. Okay, let's talk about transferring to the civil docket. Now, the difference between the two is one is very informal, comes before a clerk magistrate or assistant clerk.
Single hearing.
Yeah, and you get to present your evidence any way you want to present it, basically, other than, talking about things that are completely irrelevant. But that on one hand, and then you're talking about transferring that case for some reason to a civil docket, which now becomes very formal. You have the rules of evidence to live by. You have civil procedure to live by.
Probably need to hire an attorney.
So How often do you see that happen?
Not an awful lot. My understanding is one of the reasons that you might ask to transfer a case where I would absolutely have to let you transfer it would be because of the defendant. Let me back up. The defendant has a right to appeal and have a new trial before a judge or jury, but that judge or jury is going to be informed of what my decision was, so that has a certain prejudicial effect.
Right.
So if somebody raises that to me, says, I want to transfer it because I've lose, or that's somehow an impediment to it, then I can't refuse. The most common reason to transfer is because there might be a counterclaim that's well in excess of the limit, or a third-party action, or it might be a very complicated case. And in small claims, we don't have, or we don't use the rules of civil procedure and the rules about discovery extensively. So it might be the kind of case that needs a lot more attention. The flip side of that is that it shouldn't be used as a way just to frustrate the plaintiff. And so as a clerk, I'm on guard for that. The rule, and I actually checked this today, the rule says you have to file a motion to transfer prior to the trial date. Because the thought was somebody's going to show up and frustrate the plaintiff, and now they have no choice. So as a clerk, I have to be on the lookout for that. And if it's a case where they say, you know, we need it in small claims because we need some kind of discovery, I can say, what discovery do you need? We can parse that out. We can work with you. Let's see if we can keep it here in this forum. So
It's my understanding also, and correct me if I'm wrong, that if a civil case for, let's say, $5,000, which is well under the limit, is filed in civil case, the judge can transfer it to small claims. Is that true?
You know, I've never seen that. I've never seen that.
I thought I had seen it
It
once.
may be the case. I've never seen that.
Okay.
I mean, there'd be nothing to stop, by agreement of all parties, dismissing the civil action
that's
and
true.
refiling.
Right.
The thing to remember, and the reason I would want to make sure before I signed on to that would be, if you're a plaintiff, you give up all your rights to appeal. That's the disadvantage.
Right, exactly, yeah, if you do that.
So if somebody is in the civil forum, that would be the easiest thing, is to raise your hand and say, wait a second, if you send me back to small claims, I have no recourse.
Not to mention the filing fee that you just forfeited.
Yeah, right.
Yeah.
Right.
Okay, and also the service that you probably had to go through at that point. Small claims can also be transferred to two other places. One is housing court. Have you seen that done?
Yes.
Okay.
Not terribly often, but yes, if it's a landlord-tenant matter, and I believe it's service of the notice transfers it. It's not a debatable thing, it transfers. So we do see those. The advantages, I'm told, in housing court is that they specialize in housing matters, and they actually have housing specialists.
They have
that will
housing
assist.
specialists whose
So-
job it is to resolve these cases.
Right.
And speaking at least for the Northeast Housing Court and the Worcester Housing Court, they're wonderful. These people know their job. I don't think I've ever had a case that they have not been able to resolve. They're a valuable resource.
these are what we call probation officers, actually.
I guess they are, yeah, but
Yeah.
I
They
guess
call them housing court specialists.
specialists, yeah.
Yeah, but I think
So-
they're attached to the probation
So there may be
department,
a really good reason. Again, although we're more limited, there may be a delaying tactic reason as well.
Sure.
You know, and as you know, I'm a neutral party. The courts are trying to keep an even playing field, so we have to some extent, always be keeping an eye on the playing field. The other piece is medical malpractice
Right.
cases. That there is a statute in Massachusetts which says that a medical malpractice case cannot proceed until it's gone through this screening process in Superior
tribunal.
Court,
Correct.
the tribunal.
Right.
And that, and I think there's some case law kicking around, that holds for small claims. And so, and I've only had a few of these. If you're trying to sue your dentist because you thought, or you think he did something wrong in your mouth, you're going to be stuck with the case being forwarded to Superior Court, which is now in Woburn.
Right.
And and they'll have
Which,
to.
by the way, is a whole lot better than Cambridge, okay?
It may be,
thought I
but
would let you know that.
I can tell you, I can tell you because a colleague called me a few weeks ago because she had such a case, and she was just trying to remember if it was the case, and the litigant, the plaintiff, was a person of limited means and real transportation issues.
Right,
And
right.
being told to go to Woburn, absolutely, there was no
Put the
way she could
kibosh
handle
to
it.
it.
So,
That's the end of
and I don't
that,
have an
yeah.
answer for those things other than to say that's a statute, it exists, and I believe it's a must.
It is.
You
It
don't
is
have a
must.
choice, so.
Yeah, yeah. Let's talk about, we get a judgment, whether it's an agreement to judgment or Wendy comes down with a judgment on the side of the plaintiff and for a dollar amount, because that's typically what happens, although you can also
There
have
is some
equitable.
There is.
Right? And by that, I mean, she doesn't only award damages in terms of money, but she can also award damages in terms of you need to stop doing that, whatever it is.
Or the one that comes up, I've seen several times, if somebody buys a car in a private sale, and it doesn't pass muster, so I can order money returned and you return the car.
You get the car back,
You know,
right?
so-
Which is not money damages on one side, but it is
Right.
on the other. So,
So-
yes, so there are multiple types. But once we have gone through the review process, which is, to me, a godsend, and we've been in it in Ayer for so long.
You mean the
I mean,
payment review?
Payment review, I can't even
well,
remember
it's
when
funny
we couldn't do it.
Well, it's funny
But-
because there was a time when we couldn't,
Right.
and we hear the complaints about the ineffectiveness of that process, and at the time when it came into effect, we thought it was wonderful because it,
We still do.
oh good,
Yes, we
oh
do.
good, oh good.
Yes, we do.
Oh
Yeah,
good.
it's automatic, less cost for everybody, and yeah, it's effective. And so after you go through that process, we do occasionally, not very often, of course, but we do occasionally have people that don't show up for court. Surprisingly, don't show up for court. And we have to pursue them by other means. Francine, what are some of those means?
Well, if the judgment comes down, there's a payment review date. If the payment review date goes and I haven't heard from anybody, no payments have been made, I go in for the payment review date. If they don't show up for that, a capias issues. And a writ of capias is a civil arrest warrant. It's not an arrest warrant as if the
Criminal.
the
It's
criminal,
not a criminal
no,
one.
you're not going to get pulled over for a speeding ticket and get arrested. However, it does give the person holding the writ of capias the right to contact a constable or a sheriff to go and arrest you. It will cost them, but they can actually arrest you and bring you before the judge to explain why you haven't paid this judgment. And very often that will be forwarded, or the sheriff will use the writ of capias to bring you back into court voluntarily, send you an orange notice that says you better appear in court on this day to explain why you haven't shown up for any of your other days. And the writ of capias, if the person holding it needs to enforce it, that cost gets added to the judgment, which gets added to the filing fee. So now, and I've seen it time and time again, what may have started out as an overdue bill for $150, somewhere in the contract that you signed, attorney's fees are awarded. So add my fees on top of that, add the filing fee on top of that, add post and pre-judgment interest on top of that, and then the constable fee. And now your $150 judgment is $500, and there's a guy knocking on your door waiting to put the cuffs on and haul you down. We usually try to enforce the writ of capias without incurring extra costs first. I personally will send a letter and say, hey, we've got the writ of capias for you. You want to give me a call, pay it, do something, or I'm going to have to send the constable or the sheriff after you. If I still don't hear anything, then yes, the writ does get forwarded to a constable for enforcement.
And they're pretty effective.
They are.
You know, they've
Having a guy with a gun and handcuffs show up on your doorstep and demand payments is very effective.
Yeah, well, it would be in my household, I'll tell you that much. Okay, but Wendy, occasionally people show up for that 30-day review and they say, I'm unemployed, I don't have any assets, I'm broke. I mean, I'm living with my girlfriend. What do you do? They do a financial statement and
we
it
do
kind
a
of shows
financial
zero.
statement, and
you
this
know?
is a question we're asked continually, and I think we have to start with the premise that the court can only order you to pay for monies that you have. We can't get blood out of a stone, we can't manufacture money.
Right.
And in addition to that, there are some federal laws that say we can't order you to pay out of protected monies. Social Security, unemployment benefits, workers' comp. I believe the theory is it's government money and you're not
Right.
going to pay a private debt. So it's a difficult balance sometimes with the payments. And I was listening to Francine that, at all stages in this, it is helpful for parties to be informed, to know what they're getting into, to, for instance, in the scenario you laid out, what if that person is judgment proof? You may be, and now the judgments are good for 20 years, but you may be stuck with the fact that you've just spent $300 or $400 to have a sheriff arrest them and they're judgment proof. The flip side is, they may be judgment proof today, but then they come into money and now the defendant incurs.
Certainly.
So there's a little bit of strategy in all of this, and we experience people who are not particularly well informed and think that you file a case and you go directly to here's my money, and it's not that simple.
Right, you're going to pay them the money.
Right, because we don't have debtors' prisons. We don't punish people purposefully for not paying debts, and a lot of people, for a variety of reasons, do come on bad times and just can't pay, or maybe just can't pay today. Now, the other piece of that is that, and you folks can correct me if I'm wrong, but in a pure supplementary process proceeding, the burden's on the plaintiff to prove that they do have money. So, I might be limited in what I can do to find out what their assets may be.
Right.
So the court is there to, to enforce orders and to make reasonable orders, but the plaintiff bears some burden if they think somebody's hiding money, to give us some evidence of that.
Right, but that's also our opportunity as attorneys to get discovery, which I didn't want to get into because no one except an attorney understands what discovery is, at least most people don't. But it is to get your bank records, to get your payroll records, to get, all sorts of records that wouldn't be available to you before in the small claims action.
And going back to, my original thought about all of this is that be informed with the choices you make.
Right.
So if
Going all the way back.
Going all the way back,
Right,
is
exactly.
small claims the right forum for you? Because if you're dealing with a person who is very skilled at hiding assets or evading orders, you may want the more formalized, expanded
Civil.
processes of a regular
True.
civil suit.
True.
And if you've chosen a small claims, you may be stuck with that. On the other hand, we've heard from lots of people who it's just a principle. It's just the principle. I want my money because it's the principle.
We had this conversation earlier this day.
And they're willing to expend all kinds of monies. Or occasionally somebody will come in and say, I know they're working under the table, and they'll provide some kind of evidence to prove that. And then through a series of coercion and various things, we can prompt payment. So, it's at the end of the day, I think being informed, having as much good information as you can, is your best ally.
Well, right, exactly. And that is one of our jobs in the beginning, to make sure that we have someone that we could actually collect from at the end. Because winning, we're not necessarily in this for the thrill of going through
The gold
court
star that you
and
won.
trial and so on and so forth.
For some
If there's
people,
nothing
that
at-
is. For some people, and I talked to
That's
somebody
true.
just the
That's
other
true.
day and he reminded me that he was 80-something and he wouldn't be here in 20 years when the person could maybe, but for him it was a principle.
Right.
So for some people, that is.
We've had people tell us that over
Yeah,
and over.
so, but be clear about what it is that you want to accomplish and what it is that you can accomplish.
Right.
And then that will help you make good decisions.
One piece of advice to the defendants in small claims is show up. Ignoring it
Doesn't
not
make it better.
go away.
Doesn't make it
It will
better.
just continue to snowball for people, even
The
if I-
interest alone.
Exactly.
The interest
The
alone.
attorney's fees, the filing fees, the court fees, it all starts to snowball. The person that is suing you continues to get angrier and angrier, where it does become the principle of the thing.
Right, right.
If somebody, as a plaintiff or representing a plaintiff, if somebody contacts me and says, listen, I know I owe the money, assuming they do owe the money, I can't pay, no ability to pay is valid. I understand people get hit with hard times. Let's put this down for a review in a couple of months. Or promise me what you can pay. Get me $25 a month, $50 a month, depending on what the debt is, and it's all fine.
Or
Ignoring
people-
it doesn't make it go
People
away.
will resolve a case by taking less.
Sure.
I mean, that doesn't happen
happens
with
too.
me. It happens outside of court. But
Right,
if
right.
somebody has exhibited good faith, you know, the person collecting the money will agree to settle for something less, weighing the advantages of
Right.
money, you know, money in hand and
Right.
two birds down
And
this
the good
road.
faith, I think, is the issue.
Exactly.
Yeah.
If you
And
see the good faith, I think a lot
Yeah.
of people are willing to
Personally, yeah.
work with
And
you.
if you truly feel you don't owe the money, call the person suing you and explain, I don't think I owe this because, and have your day in court. Let the magistrate decide.
There are an awful lot of folks who, for whatever reason, are afraid of the process, intimidated by the process, just have so many things going on in their life that they're overwhelmed, that I suspect a lot of the defaults or failures to appear are based on that. But you're absolutely
do
right.
too, yeah.
It doesn't get better because you put it off.
Nope.
Because all the fees the plaintiff incurs are ultimately chargeable to you.
Now, let's talk about, we already talked about the military affidavit.
An important piece because,
Yes.
and I want to remind people because we had Fort Devens right in our backyard.
Right.
And years ago, I remember talking to colleagues in other courts who didn't even know about that because they didn't have a military installation. But it is an important piece, and there is on the website some numbers you could call to find out if somebody's inactive.
There's a website you can
Status.
go to. I think it's
Yeah.
military.org or something. I just
And
looked it
the,
up
and
the
the
other day.
theory is
Yeah.
that you shouldn't be sued and have a judgment against you if you're serving the country.
Right.
So,
Right.
so it's an important piece.
And it makes you somewhat unavailable anyway, for the most
Yes.
part. Now, let's talk about the appeals process.
Mm-hmm.
Now, this is an interesting flick in small claims
Mm-hmm.
because in small claims, only the defendant can
Yes.
appeal. You've raised that a couple of times,
Yes.
and I hope people get that.
By the way, there have been movements through the years to establish a plaintiff's right of appeal. I personally am for it, but
I am too. I
but
mean, I think one side gets it, the other side should get it. But
you know, every time this has come up, it's gotten nowhere. But if people feel strongly enough about it, you go to your legislator, and you know, and voice your opinion.
get it changed.
I'd
Yeah.
also read in the rules that if your small claims case is heard by a judge and not a magistrate, that you cannot appeal, even if it's in small
Right.
claims. Yeah.
Well, when they it was 1993 or 4 when they changed the statute to say that magistrates hear these in the first instance, and the appeal by the defendant is to a jury, or if they waive jury, a judge. There is provision if it's usually in courts where maybe the magistrates aren't available to have a judge hear the case. But once the judge has heard the case, you can't then appeal that judge's decision to another judge.
Right.
So, you know, it's just a little wrinkle that we should all be
I
aware
have
of.
been in small claims cases that were, small claims courts that were heard by a judge, not a magistrate.
And then you would lose.
Would lose the right to appeal.
Yes.
And once you've had that appeal, there is no further
There's-
appeal.
Essentially, no appeal, other than what might be a 211, you know, to
Right.
the SJC superintendents. There's no other right of appeal. But my understanding is there's no right for a report to an appellate division unless a judge were to, he or herself,
Send it up on
send
their
it up.
own.
And I've never seen an issue that gets framed that well and presented to a judge.
I
and a
have read
judge.
some that have gone up, but
There are a few.
they're pretty.
Yeah, far and few
pretty,
between.
yeah, pretty
So
unique.
there is essentially no right of appeal. And for plaintiffs, again, that's an important piece of the puzzle. One, because small claims is an alternative procedure. You can choose between a civil or a small claim. So once you've chosen small claims, that's it.
Yep.
As a plaintiff, yeah.
The perception
Mm-hmm.
of an appeal before a judge or a jury is, well, I don't want to go before the judge because the judge works with the clerk magistrate. And of
Lord.
course, if he says or she says that I should pay, then you know that's what the judge is going to say. Go ahead. Give me a comment on
Well,
that.
I mean,
You got to give me a comment on that.
I mean, I know there is that perception. You know, I would say ethically, we're prohibited from, you know, going to a judge and saying, you know.
Anything about the case.
And honestly, I don't track my appeals, you know, because I found there was no value to it to me. It's very often a very different case when it goes before a judge.
Sure.
Because they've had the opportunity to
See it
reflect
once.
on what they did the first time. I have had judges come down or come to me and say, oh, I heard that appeal and you did this and this is what I did, and we might have a discussion after the fact. But no, that's kind of urban legend, I think, to some degree.
But there is an advantage to going before a judge because you can get it rather quickly compared to a jury.
Yes.
And the jury process.
The jury process is the regular jury process that exists for criminal cases. It's a 6-person jury. We have juries in Ayer. The problem from a practical standpoint is that in the hierarchy of business that we have, small claims is fairly to the bottom. And different judges handle small claims differently. Some think they're fun and you know, want to dig their teeth right into it, and others, I think what you have to remember is judges are used to trials that involve attorneys where all the rules are being used, and when you're dealing with pro se litigants, you have to kind of walk people along, and so for a variety of reasons, you may not get a jury trial that quick. That quick.
Yep. I think we've kind of come to the end of our time, but I just wanted to say that everything that we said here today is basically a Massachusetts thing. We're talking about Massachusetts small claims courts. So regardless of what jurisdiction you're in, you might find something that is done a little bit differently, but they follow the same rules. For those of you who are watching in other states, it probably doesn't apply to you at all. I don't know.
Go to your local court.
But keep in mind, check with your court clerk and find out how they do their small claims. Again, I want to thank you for both of you for showing up and giving me everything you had on small claims. It was a pretty good show. And I want to thank all of you out there for listening, and I hope to see you again next time.